All right, I'm going to let the lawyers in. Mr. Slavin. Here, okay. There you go. Okay, I just want to be sure we're all here. All right,
Yes,
good
ma'am.
afternoon, everybody. Ms. Flores, can you call court for us, please?
Yes. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, the court calls case number 08-20-00205-CV. Davis versus COG Operating. And I understand, so let me just be clear, Mr. Slavin, you're going to use 15 minutes and Mr. Wade 5 minutes. Is that correct?
That's correct, Your Honor.
Okay, terrific. Thank you. And so with that, for those of y'all who haven't argued before us before, we have had an opportunity to review the briefs, the record, and have a discussion amongst ourselves in regards to the issues so that we are familiar with the underlying record if that aids you in your presentation today. So with that, I will turn it over to Ms. McNair. Thank you.
Thank you. Good afternoon. May it please the court and my opposing counsel, Audrey Vicknair, for the appellants. This case involves the construction of mineral deeds executed in the 1920s and 30s. On competing motions for summary judgment, the trial court granted the Neal Appellee's motions, denied our motion, and as a result has removed an NPRI that burdens the Neal's mineral interest. But that NPRI was clearly and expressly reserved in our predecessors in a deed that was duly recorded. We assert that the trial court's stripping of our NPRI must be reversed and rendered by this court. Even the Neals do not dispute that we have a clear unbroken chain of title, but to strip us of our interest, they have misrepresented various interests conveyed in these deeds. They have tried to apply legal theories that don't apply or have been rejected, or they otherwise ignore controlling authority. So the standard of review is de novo, and the 1926 and 1939 deeds, which no party says are ambiguous, are the focus of the inquiry. So as the court knows from reading the briefs, our predecessors are the Sesslers. In 1926, they owned 100% of the surface and 100% of the minerals in a tract in Upton County. That year, they conveyed to W.H. Hahn a 1/4 mineral interest. That deed was duly recorded. Then in 1939, the Sesslers conveyed to Roberts, who's the Neal's predecessor, all the minerals they owned. They expressly accepted from that deed, not once, but twice, the mineral interest that was previously conveyed to Hahn. The Sesslers did not reserve any mineral interest in themselves. Instead, they clearly and expressly reserved a 1/4 floating NPRI. So to advance their interest, when you review the Neal's brief, you can see that they misstate in a variety of ways the interest that were conveyed in the 1926 deed, the interest that was conveyed in the 1939 deed, and the interest that the Sesslers reserved in themselves. And the court should not be misled, because the reason they're doing this is to try to apply the Duhigg doctrine to strip us of our NPRI. But the Duhigg doctrine does not apply. As the Neals recognize in their brief, the elements for the Duhigg doctrine include that the grantor conveys a mineral interest to the grantee, the grantor fails to disclose that any portion of that interest has been conveyed to another, and then the grantor reserves some of that mineral interest in themselves. In that event, the mineral interest is considered to have been overconveyed. And what happened in Duhigg is the court thought that equitably, the grantor, which had reserved some interest in itself, had to give that interest to the grantee. We don't have any of that in this case. Dora Roberts took that 1939 deed with express reference, not once but twice, to a mineral interest previously conveyed to a named grantee, W.H. Hahn. She knew that a part of that mineral interest had been conveyed to Hahn. That 1939 deed does not reserve any mineral interest in the Sesslers. The Sesslers conveyed all of the mineral interest that they owned. Now, what's interesting, well, there was no overconveyance of minerals. And what's interesting is the Neals aren't actually arguing that there was an overconveyance of minerals. In that event, Dora Roberts would have had to sue for breach of warranty. She didn't do that. So instead, what the Neals are trying to do to take our NPRI away from us is say that there was a previously conveyed royalty interest that was not disclosed in the 1939 deed and use Duhigg that way. Of course, that argument, as you can see from our briefing, is flawed fatally for a number of reasons. First and foremost, Duhigg has never been applied to a royalty interest. The Neals failed to provide this court with any case law to support their position. They cite one case, Wensky, but the majority opinion in Wensky says nothing about Duhigg. No party argued Duhigg. In addition, you can see from our briefing, decades of courts retracting Duhigg and limiting the application of Duhigg, not expanding it. And we're asking this court, please not to expand Duhigg as the Neals contend. The other problem that the Neals have is that there is no previously conveyed royalty interest that's not disclosed by the 1939 deed. Again, that deed put Roberts on notice of a previously conveyed mineral interest to Hahn, which would have carried with it the landowner's royalty. Once again, no failure to disclose a prior conveyance. By virtue of estoppel by deed, Roberts was charged with notice of that prior conveyance, that 1926 duly recorded deed. Again, the grantee of that conveyance is expressly named twice in Roberts' deed. She's well aware of who he is. The face of that 1926 Hahn deed shows that it was a 1/4 mineral interest that was conveyed with the corresponding 1/4 landowner's royalty. Remember, these were executed. Yes.
I'm sorry, can I slow you down right there? And what particular language in the deed can you point us to for that conclusion that was what was conveyed, a 1/4 interest in the mineral estate?
Absolutely. Your Honor, these deeds were executed in 1926 and 1939. We know at that time, landowners were operating under estate misconception. We know that there was the legacy of the usual 1/8 royalty. In fact, courts refer to that in deeds of this genre as things that the court can almost take judicial notice of. At that time, when landowners were conveying mineral interests, very often they did so using multiples of 1/8. So a 1/4 is stated as a 1/32. We have cases in Greer, for instance. This court looked at a 1927 deed. The fraction of mineral interest was 1/16, but the royalty was 1/2. This court knew that a 1/2 mineral interest was conveyed with the corresponding royalty interest. There's Concord Oil, a big Texas Supreme Court case from 1937, a 1/96 in the mineral granting clause and 1/2 in the royalty. The court held that, or 1/12 in the royalty, the court held it was a 1/12 mineral interest that was conveyed with the corresponding landowner's royalty.
Okay, so I guess just to be clear here then, because I'm looking at the 1926 deed.
Yes, Your Honor.
And I guess it does say 1/32 interest. Is that what you're referring to then? That would be equivalent to the 1/4?
Yes, Your Honor, because in addition, as we know, what the Neals have advanced is this idea of a 2 grant in this 1926 deed. What they're trying to tell the court is that there was a mineral interest that was conveyed and this separate, different fraction royalty interest below. the watershed case on this is the Texas Supreme Court case of Concord Oil. Concord Oil expressly did away with this two grant notion. Concord Oil said that first of all, we look at the deed as a whole. We, how do you say it? We look at the fractions together. We recognize the legacy of the 1/8 royalty, and courts know that if the mineral interest in the 26 deed says 1/32, every other fraction in this deed, Your Honor, says 1/4. So we know, looking at this entire deed and harmonizing all the provisions based upon all the authority and the vintage of this deed, 1926, that is a 1/4 mineral interest that's been conveyed to Hahn. There are not two separate interests that are conveyed. The mineral interest is not a different interest from the royalty interest. When a mineral interest was conveyed to a grantee, a corresponding landowner's royalty of the same amount went with it. And so we say that a state misconception applies to both 1926 and the 1939 deed. When Dora Roberts got her deed, she knew from the face of it that there'd been a prior conveyance to a named grantee, W.H. Hahn. And she knew from the face of it that a mineral interest had been conveyed to Hahn, and with that mineral interest went the corresponding landowner's royalty. Now, the elephant in the room in this case is the title opinion that Dora Roberts received right before she was given this 1939 deed. She had counsel. Her counsel found the 1926 deed and gives her a title opinion, which we've imaged in our brief, that shows her very clearly in 1926, the settlers conveyed to Hahn a 1/4 mineral interest. Now, the Neals don't want any of the courts to think about that title opinion. They don't want anybody to look at it. But at the same time, the Neals are relying on a lot of extraneous documents to try to say that we should be stripped of our MPRI.
Okay,
what we say yes,
what is your position on whether or not we can consider the title opinion with our analysis?
Our position is that that is actually a surrounding circumstance, because that title opinion was presented to Roberts within about a week of this deed. The title opinions from the end of April, the deeds from the beginning of May. That was a surrounding circumstance when she had this deed in front of her to tell her that what was being conveyed to her expressly accepted a 1/4 mineral interest in Hahn. And then we know from the face of this deed, it reserved in the settlers a 1/4 floating MPRI. So we say that that is a surrounding circumstance that can be considered to understand the interest that was conveyed.
Do we
Dora
still
Roberts- Yes, Mom.
still reach the result that you're asking for if we don't consider the title opinion?
Yes, absolutely. Because again, with what we know about estate misconception, the legacy of the 1/8, with deeds of this vintage, we also know Dora Roberts was on notice from the face of the 1939 deed that there was a prior conveyance out there to a named person, W.H. Hahn. We say that she is bound to know and understand all of the instruments in her title. This court held that in Greer. A purchaser is bound by every recital, reference, and reservation contained in or fairly disclosed by any instrument which forms an essential link in the chain of title under which he claims. Courts hold grantees are bound by recitals in their chain of title. So Dora Roberts, being the grantee, is bound by the recitals. She's bound by a prior conveyance of a mineral interest. It's stated as a 1/32. We've got a state misconception, and we've got the legacy of the 1/8 royalty. And then Dora Roberts knows that with a mineral interest having been conveyed, there's a corresponding landowner's royalty that goes along with it. For all of these reasons, we say that the Duhigg doctrine just can't apply. There's no overconveyance of minerals. She was on notice of the previously conveyed mineral interest. The settlers didn't reserve a mineral interest in themselves. They conveyed everything they own. Duhigg does not apply to royalty interests. We know the two grant doctrine is dead. And when Hahn was conveyed a 1/4 mineral interest, as we can see from the 1926 deed, the corresponding royalty interest went with it. That is the one of the main bases that the Neal appellees want to use to strip us of our MPRI. And we
So
yes.
it's very, I'm sorry, I keep stepping on you, but
No, that's okay.
you're quick, you're a quick talker. So your position relies obviously very heavily on our adoption of the estate misconception doctrine in our analysis. That's true, correct?
Yes, Your Honor, estate misconception is certainly part of the analysis. Yes, Your
Okay,
Honor.
so can you describe for us all of the underlying, all the evidence within the deed that we should adopt that doctrine in our interpretation of this deed, or both deeds, actually?
Well, we know that if we start, well, I guess we'll go in chronological order. We know that the 1926 deed, the law requires us to read all of these provisions together and in harmony. And we know that in case after case, when the mineral interest is a fraction that's a multiple of a 1/8, and all of the rest of the fractions in the deed are a different number, it's the smaller fraction in the deed. And I'm not saying it very artfully, but in the 1926 deed, you had a 1/32 in the mineral conveyance, and every other fraction in the deed is a 1/4. Case law, binding precedent would establish that that deed conveyed a 1/4 mineral interest to Hahn in 1926. The 1939 deed puts Dora Roberts on express notice of a prior mineral conveyance to Hahn. That deed also talks about a 1/32 mineral interest having been conveyed, applying estate misconception, as we all understand would have been the issue back in the 1930s. That put her on notice of a 1/4 mineral interest. Certainly, she was on notice to go find the prior conveyance to Hahn and see just exactly what it was that was conveyed to him. Now, beyond Duhigg, we also have two other issues that the Neals have raised to try to strip us of title. So we have the presumed grant doctrine, and of course, presumed grant does not apply. Presumed grant is a legal theory that applies when you're dealing with ancient documents in a chain of title, and there are documents missing. In our case, we and the Neals put forth and filed abstracts, which have not been disputed. It's been agreed to by the parties that those are fully and completely before the court. Those abstracts are virtually identical. From Volney Johnson in 1908 through the Sesslers down to Roberts, there's no documents missing. There's no argument that there's anything missing in the chain of title. We all agree on the chain of title. In fact, for that matter, there is no dispute that the 1939 deed reserved in the Sesslers a 1/4 floating MPRI. There is no dispute as to that. Instead, what the Neals have tried to do is take that MPRI away from us using Duhigg, using presumed grant, which as we're discussing does not apply, and then also limitations, which I'll get to in a minute. The last thing I want to say on presumed grant is that that's sort of built on adverse possession concepts. The Neals recognize that adverse possession does not apply to non-possessory royalty interests. MPRIs are non-possessory royalty interests. At the summary judgment hearing, the Neals abandoned their adverse possession arguments. So presumed grant fails for that reason as well. And we want to note here, the Neals recognize if we prove superior title to the interest from a common source, we prevail, and we have done that. No amount of fact twisting and legal arguments can strip us of that MPRI that everyone recognizes we own. Finally, yes, Your Honor.
Stop you for a second. Was there an oil and gas lease in effect in 1939 when the conveyance from the Sesslers to Roberts was made?
That is a good question, and I will try to find the answer for that for you and come back on the reply. Right off the top of my head, I'm not sure.
Okay.
Okay. Regarding limitations, We have trespass to try title and we have declaratory judgment action. As to trespass to try title, that's what the Neals say this case is. The law provides that the only defense to trespass to try title is adverse possession. And as we've just talked about, the Neals abandoned adverse possession. So trespass to try title is a live action. We have also alleged declaratory judgment. The reason we have done that is because the courts have not yet sort of given us a definitive answer on whether an NPRI is a trespass to try title or declaratory judgment type of an animal, if you will. We believe declaratory judgment is also appropriate. We're dealing with deed interpretation here. We're dealing with a non-possessory interest. There is not a chain of title problem, and we are persons interested in a deed seeking declaration of our rights. We've pled both causes of action or both vehicles, if you will, and advanced both of them here to protect our interests. Regarding a declaratory judgment and limitations, because we're dealing with an interest in real property, the residual 4-year limitations period does not apply. An NPRI is an interest in real property. In addition, we acquired our interests in late 2017 and early 2018. We demanded that our NPRI be acknowledged and were rebuffed, so we filed suit. So we filed suit within a year of acquiring our interest. So under any cause of action, we have timely filed our lawsuit. And also many of the cases we cited in our briefing are declaratory judgment actions dealing with deeds of vintage back in the 1920s, 1950s, but the lawsuits were filed in the 2000s because there were new interest owners, new stakeholders, and what have you. So we would submit that we pray the court to reverse the trial court's judgment and render judgment in our favor on title. And then as to the ancillary claims, as you can see from our briefing, we believe the trial court is in the best position to handle those on remand. Thank you.
Thank you.
All right, thank you very much. And now, Mr. Slavin.
Thank you, Your Honor. May it please the court, counsel. The Neal family has owned 3/4 of the royalty interest in Section 45 since 1941, when their father purchased Section 45 from Dora Roberts. That's for over 80 years. During that span, the Neal family entered recorded oil and gas leases and received royalties based on that 3/4 royalty ownership. At no time during those 80 years has any Sessler heir sued, claiming the Neal family only had title to 1/2 of the royalties rather than the 3/4 royalty ownership they had always been considered to have owned. 36 years ago, in 1984 and 1985, an attorney for the Sessler heirs wrote Saxon Oil Company, who was the Neal family's lessee of Section 45 at that time, alleging that the Sesslers owned some portion of the royalty interest in Section 45 where Saxon Oil had drilled 2 wells. Saxon Oil Company wrote back, advising that the Sesslers owned no royalty interest because the 1939 warranty deed overconveyed the royalty interest to Dora Roberts, which was made up by the 1/4 royalty interest that the Sesslers reserved in that 1939 warranty deed. The Sessler heirs never challenged that position and never sued the Neal family, making such a claim to this day. In 2017, JD Minerals is searching the Upton County public records, looking for any long dormant, unrecognized mineral claim in the hopes of busting title and is filing litigation. Thinking they had discovered a royalty interest claim from 80-plus-year-old title documents, JD Minerals set out to acquire all they could from the Sessler heirs and then filed this lawsuit on April 13, 2018, a mere 4 days after they acquired the last Sessler heir interest that they were attempting to obtain. The JD Minerals lawsuit sought to rip from the Neal title to royalty interest they have held for 8 decades. The lawsuit asserts numerous other causes of action for conspiracy, tortious interference, a host of other claims that from something they acquired 4 or 5 days earlier, suing my clients, the Neal family, for punitive damages and actual damages. Again, I represent the kids of Jess Neal, who bought this property from Dora Roberts in 1941. It has been in the Neal family since 1941. Now, all agree that construction of the Sessler's 1939 warranty deed to Dora Roberts controls the application of the Duhigg Doctrine. So why do appellants immediately pivot to construction on a 1926 royalty deed to which Dora Roberts was not a party and which is not mentioned, not quoted, and not incorporated in the terms of the 1939 warranty deed? Appellant needs to distract you from what they admit controls. Understand this is a warranty deed, and it's interesting they don't mention warranty deed in one spot in the 80 pages of documents, but this is what controls, what was warranted to Dora Roberts that was being conveyed to her. That warranty deed does not incorporate, it does not reference. All it says is there was a 1/32 mineral interest accepted for Juan. It doesn't say when, it doesn't say how, it doesn't say where. They want you to rewrite that exception to say it really is accepting a 1/4 mineral interest. Is 1/4 mentioned anywhere in that 1939 warranty deed? Absolutely not.
Counsel, I think,
Now,
as I understand their argument, though, they're kind of saying that people in 1939, if they said 1/32, they really meant a 1/4 interest because 1/32 is a fourth of a fourth, I suppose. And
all right.
And so I guess if that is the law, if that's what that term means, where does that leave you with your other arguments with like the Duhigg Doctrine?
Well, that's a distraction, I believe, Your Honor, because you got to look at what they were warranting title to conveying. If they had said, we incorporate generally, if they had just said, we incorporate all prior conveyances, like several of the cases they cite, that might take it out of the Duhigg rule. If they had said, this conveyance is subject to all prior conveyances, or subject to a prior conveyance of a 1926 warranty deed. Now, and when you look at that 1926 royalty deed, you will see it is conveying a 1/4 royalty in existing and future leases. And in fact, what I would ask you to do is look at their live pleading. Look at all their pleading. Look at all their petitions, including the third amended petition. Look at what they wrote the Neals a couple of weeks before they filed this suit. What did they say was conveyed by that 1926 royalty deed? They say one was conveyed a 1/4 NPRI by that royalty deed. Now, they pivoted here to now say it's a mineral interest, but they called it all the way, including the live pleading that led to this appeal, the third amendment petition. Take a look. It is referenced as a 1/4 NPRI to Juan. They reserved a 1/4 NPRI in themselves. They conveyed a 3/4 royalty interest to Dora Roberts. This is a classic Duhigg case because that overconveyance, as they were told 33 years ago, that overconveyance is taken from their interest. And let me address one thing quickly. Counsel said that Duhigg does not apply to royalties. That's just wrong. Look on page 13 of Appellee's brief. We cite to the court the Selman versus Bristow case. a 1966 case. Take a look at that case. That case applied Duhigg to a 1/8 royalty interest that was previously conveyed and not listed in a later deed. And what did they take that overconveyance out of? A 1/4 mineral interest. A 1/8 royalty interest previously conveyed, taken out of a 1/4 mineral interest. And the Supreme Court denied refused writ. And what did it say all the way back in 1966 when it refused the writ on that case? They did a per curiam opinion. They said, on the authority of Duhigg, the Court of Civil Appeals has held that the 1/8 of the royalty reserved by Whedon in their deed to Austin and Bristow must be carved out of the 1/4 mineral interest conveyed by Austin and Bristow in the deed to Selman. We are in agreement with this holding. So for 55 years at least, Duhigg has applied to royalties. And that's in our brief. That's a case on page 13. Take a look at that. So you've got them saying, okay, one got a 1/4 NPRI. And until now, if you look at the 1939 deed, it only reserves a 1/32 mineral interest. So it doesn't reserve 31/32. So 31/32, if my math is correct, is greater than 3/4 mineral interest. But again, it only carves out as of the royalty 1/4, which means we get 3/4. And you can divide minerals and royalties. We know that. We cite the cases there. But what was warranted to Dora Roberts and to my clients as successors was that they were getting a 3/4 royalty interest, and with 1/4 left to the settlers. But the settlers couldn't do that because they'd already conveyed 1/4 of all royalties from future and present existing leases in 1926 to Juan. And Your Honor, in 1926, there was an existing oil and gas lease. In 1939, I don't think it was in existence anymore. And in the 50s, it began being leased again. So from the 50s through 2018, when they filed this suit, my clients were receiving 3/4 of the royalty on this claim. So for those reasons, we think this is clearly a Duhigg case. It clearly applies to royalty interest. Take them for their word on what they pled in their answer. Now, talking about the 1926 royalty deed would be, you would have the right to do that if it was even mentioned in the 1939 warranty deed. It is not mentioned. If they had just said, this conveyance is subject to all prior conveyances of record, that would be enough. But look at the cases that talk about that. Now, these other issues may have been a mistake, let's say, and what the courts say, there may have been a reformation action, but when should they have filed an action to reform that deed? They want to reform it now, essentially. They want you to change it from saying a 1/32 mineral interest was accepted to a 1/4 mineral interest was accepted. But that's a reformation. That's a 4-year statute of limitations. Certainly in 1985, they knew about it. The property was under lease.
Mr. Slavin, then how do you reconcile then the first statement that's in the second paragraph of the 1939 deed where Mr. Hahn is mentioned, and it has the fraction 1/32? Then how do you reconcile it with the last sentence of the third paragraph where you see the second mention of Mr. Hahn?
Those are both mentioning a 1/32 interest, Your Honor. Mentioning a 1/32 interest is not accepting a 1/4 mineral interest. That's 8 times larger. To do that, they had to refer to the prior deed, or they could have simply said, we want to incorporate all these deeds, all the deeds of record. That's what the cases show. When they don't do that, They have warranted what the 1939 deed in its four corners says.
I
They
guess
want
what
you
I'm-
to,
I
they
guess
want you
what
to
I'm-
leave those four corners and grow that 1/32 that said in the 1939 warranty deed to a 1/4 mineral interest.
But it
That's-
sounds like, wouldn't it then say in the second reference, when it's giving us the subject to clause for Mr. Hahn, it says 1/4 of the 1/8 royalty. Wouldn't it
That's
need
it.
to say 1/32 of the 1/8 royalty?
Your Honor, the 1926 deed is a red herring. You're focused on construing that. Dora Roberts was not a party to that.
But I'm
It-
looking at
it's-
the
The
1939.
only way that it would be proper to even for this court to go construe that is if the 1939 deed incorporated it, referenced it, or generally said it's subject to that deed. It does not do that anywhere in the 1939 deed. Now, what you're referring to is correct. We do not dispute. This is not, if you were faced with a lawsuit between Sessler heirs and Juan's successors, and they're arguing about did that 1926 deed do a fixed interest or a floating interest? Was it a royalty interest or was it a mineral interest? All of that would play out in that. It doesn't matter to this case because the deed in the language you're looking in that 1926 deed says this: Juan gets 1/4 of all the royalties on existing and future leases. That's what it says, right?
Well, I'm looking at the 1939 deed.
Okay, I'm sorry, you said the 1926 deed. Let me find what you're referring to.
Thank you for making that your phone.
If it pleases the court, I'll yield time to Mr. Slavin. I don't want to cut into his time.
All right, I'll give you another minute, Mr. Slavin, or what it takes to answer
Thank
the
you.
question.
And I'm sorry, Justice Palafox, can you tell me what language you're focused on? I've got the language in front of me now.
If you have the deed in front of you, so it would be the lengthier third paragraph, but at the bottom of that paragraph, when it gives us the second reference to Mr. Hahn, it's describing it in fractions of 1/4 of the 1/8 royalty.
Exactly.
But earlier reference says 1/32, and it seems to me you're telling us we need to look at that fraction of 1/32 literally. We don't change it. It means what it says. So I'm struggling to, how do I reconcile the first reference that says 1/32 with the second reference, which describes it as 1/4 of the 1/8 royalty?
Well, Your Honor, at that time, 1/32 was what Dora Roberts is being told was accepted. And so, and I'm sorry, it's a little dim in here, and I don't have that language here in front of me. So let me answer that in a post letter, since I'm running out of time on that, if you will. And I need to get to presumed grant, but I'll try to answer that, Your Honor, in a brief letter. I understand your question. Thank you. So moving on to, if Duhigg does not apply, then the presumed grant doctrine certainly would preserve title to the Neal family that they've asserted for over 80 years. There are only three elements of presumed grant: a long asserted and open claim adverse to the apparent owner, non-claim by the apparent owner, and acquiescence by the apparent owner in the adverse claim. It's an equitable doctrine. It's designed to settle titles where the land was understood to belong to one who does not have a complete record title but has claimed a long time. And the key to the presumed grant cases is the long time in which all interest owners have agreed or have not challenged the ownership of the property in dispute. We have the appellants don't dispute we have evidence on all of those grounds. They try to add a fourth element, a gap in title. Running out of time, but I would quickly refer you to the Purnell versus Gulliger case out of this court in 1960. There was no gap in title in that case, and presumed grant was applied. McGowan versus Montgomery cited in our brief. There was no gap in title, but presumed grant applied. It's applied when there's been, like this case, decades of assertion of ownership and acquiescence by the Sessler heirs throughout that time. And that's what controls. I will rely on the rest of our brief to cover all the other issues unless the court has any additional questions at this time.
No, and I think Mr. Wade, I think you probably may have a minute.
Yes, if it please the court, the basis for COG's request to the court is pretty straightforward. The claims against COG in the case were subject initially to a summary judgment, and the case was there was a severance of all claims against COG, who's the operator. The court then decided after the severance was first signed on September 28th of 2020, the plaintiffs filed a motion to modify because they realized that summary judgment had been granted as to COG and the claims were severed in the severed action, but the summary judgment grant had already been granted. So once they realized that, they filed a motion to modify. And on October 23rd, 2020, the trial court signed an order granting the plaintiff's request for relief, basically taking up again the issue of summary judgment as to COG and confirming that all claims against COG are severed in a separate action. So the bottom line, our position is we're not a party to the underlying case. There's no final appealable judgment in this case against COG. And there's no justiciable live claim against COG pending in this court as a matter of law. So we respectfully request the court dismiss COG from this particular appeal, understanding that the claims against COG have been severed into another action at the trial court level.
All right, thank you. Thank you very much.
Well, just Mr. Wade, then you don't have a position weighing in on the title dispute.
Your Honor, since the beginning of this case, we've communicated with counsel as operator and have said we intend to obviously honor whatever the court determines is the title issue. And we have been attempting to work with everyone in that regard as the case has been pending. So we have adopted the title arguments that are asserted, and we reassert the arguments made by the Neal appellees. That's the way COG has been paying everything for years, COG and its predecessors. So we do adopt those positions, but obviously we will abide by whatever ruling that is made ultimately in this case.
Okay, thank you.
Thank you. Rebuttal?
Yes, Your Honor, thank you. First, Justice Alley, to answer your question, yes, there was a lease in place in 1939. But with that said, under HISAW and Concord, the courts have held that whether a lease is in existence doesn't matter, if you will, for purposes of harmonizing these multi-clause deeds. So again, we look at all of the clauses in the deed and we harmonize the fractions, and the mineral interest always is the same as the other fractions in the deed, notwithstanding whether there's a lease out or not.
Well, I guess the point of my question, or where I was going with that, is if there was a lease in existence and if royalties were being paid off of that, but not paid to the Sesslers, because I guess apparently they haven't gotten any royalties in the last 80 years, would that also be a circumstance like the title opinion that could be considered in construing the lease?
Well, I don't know that there's any evidence that the Sesslers were not being paid royalties at that time, number one. Number two, the Sesslers were very clear in both of their deeds about the Sesslers very well understood the interest that they were conveying both to Hahn and to Roberts. We would say with respect to any other surrounding circumstance, I would need to probably brief that for you, to be honest with you. In addition, I would like to talk about, go back to Duhigg and the idea about whether or not Duhigg actually applies. As the court can see from our briefing in the Texas Supreme Court recently, the Trial versus Dragon case talked about Duhigg again and talked about the very limited factual circumstance under which Duhigg applies, which again, the Neals have recognized, which is it has everything to do with mineral conveyances and an overconveyance of minerals. I also wanted to point out in that case that Leo's deed to the Dragons in that case made no mention whatsoever of a prior conveyance to Ruth. But the Supreme Court actually took the time to mention that the Dragons had not obtained a title opinion and they didn't have any actual awareness of Leo's conveyance to Ruth. I found that interesting because in this case, again, you've got a title opinion that was in Dora Roberts' hand when she had this deed conveyed to her. That seems to be an important item to discuss.
I'm gonna stop you just there for a minute. Judge, Justice Alley, did you want a letter brief on that issue?
Well, if it's not of record, if there's no record references as to whether there was a royalty payment being made or not made, then probably not. But I did, in your remaining time, I did want you to address COG, because I think I heard them say they're really not even part of this case, that they're in a severed action. And so why are they here, I guess is my question.
Well, because Your Honor, originally the summary judgment granted by the trial court did include COG. We then were able to get COG severed out, and then the court did reconsider its position. It vacated the summary judgment as to COG and abated all of our claims against COG. We had no idea what COG was going to do about that. We didn't know if COG would contest it in the trial court, contest it in this court. So because COG was originally a party to that first summary judgment order, they came along. But we have made very clear in our briefing that if COG was not going to contest what the trial court had done, and they have not, they admit that everything's severed and abated, then that's fine. And all of COG's claims await to be determined by the trial court. We hope that this court will reverse and render title in our favor. COG says they'll comply with whatever this court's ruling is. And we will go back to the trial court, merge this case back together and finish it. But that's why COG is here, because they were party to that original summary judgment order that we had to file a notice of appeal from. I heard Mr. Slavin say multiple times that if the 1926 deed was mentioned or referenced in the 1939 deed, then we should consider it. To say that that prior deed is not mentioned or referenced in the 1939 deed is to ignore two provisions that Justice Palafox has discussed greatly this afternoon, that there is absolutely a reference to a prior mineral conveyance to a named grantee named W.H. Hahn. If that is not considered sufficient notice, then I don't know what is. It didn't have to include language for all purposes. It didn't have to include language every single conveyance ever filed previously. In fact, if anything, language like that is even more sort of obtuse. Here we have actually named the grantee. It would have been very easy to go find that grantee. And of course, as we know, Roberts did so because her title opinion very clearly shows the 1926 grant to Hahn. So as we've discussed today, the Duhigg doctrine does not apply because the Duhigg doctrine must be based on very specific facts that do not exist here. The Duhigg doctrine cannot strip us of our floating NPRI interest. That 1/4 floating NPRI is expressly stated in this 1939 duly recorded deed. That floating NPRI burdens the Neals landowners' royalty. It burdens their mineral interest. We say we have a 34 3/20ths floating NPRI, which is then taken from whatever royalty the landowners, the Neals, are receiving. So we have money due to us, as Mr. Wade recognizes with COG and prior operators who did not pay our floating MPRI interest to us and instead paid it to the Neals. We've talked about the fact that courts harmonize these multi-clause deeds. We've talked about estate misconception and the legacy of the 1/8, that the 1926 deed must be read to have conveyed a 1/4 mineral interest to Hahn. Roberts is on full notice of the 1926 conveyance to Hahn. With regard to presumed grant, it cannot be ignored that presumed grant applies when you're dealing with ancient missing documents. That is a consideration that the courts make. We are the party claiming the interest. We have provided a clear, unbroken chain of title. The Neals abstract looks just like ours. There is no dispute that there is a clear, unbroken chain of title. There is no grant to presume. The grants are in the chain of title. And again, presumed grant deals with adverse possession. NPRI is a non-possessory interest. Adverse possession doesn't apply. The Neals have conceded that presumed grant simply cannot be used in this case to strip us of our floating NPRI interest. We've also talked about the limitations. Trespass to try title is alive because they abandoned their adverse possession claim. Declaratory judgment is alive because we acquired our interest. We demanded that those interests be recognized. We were rebuffed. We filed suit. For all that the Neals try to put the black hat on us, we did everything that was appropriate in this case. We timely and properly demanded that our interest be recognized. When it wasn't recognized, what else are we to do but file suit and seek a declaration that these deeds permit us this floating NPRI? We are praying the court to reverse the trial court's summary judgment. The trial court should not have granted summary judgment to the Neals and should not have denied our motion for summary judgment. They are competing on this precise title issue. We are asking the court to declare that we, appellants, have a floating NPRI which burdens the Neals landowners' royalty. That NPRI is in a quantum of 34/320, 34/320 NPRI, and all of this is tracked in the briefing, but the 34/320 NPRI burdens the Neals estate. That must be paid out of the royalties that they are receiving from these operators. We would submit that the trial court saw this case in two parts, title being part one, all these ancillary claims being part two. We would pray the court to remand all of these other ancillary claims that are all dependent on title. The parties all recognized that this was a two-part case, really argued it as a two-part case. We argued all those claims to keep them alive in this court, but recognized that for judicial economy purposes, the appellate rules would permit you to remand those claims for the parties to work it out or the trial court to dispose.
May it please the court, may I be given 30 seconds of time to address something that Ms. Vignair said about what I said? I apologize for that.
Yes.
Thank you, Your Honor. If it please the court, COG, because it has paid the Neals line of title for years, obviously is adopting and restating their arguments with regard to what action COG may take in the future. Obviously, once there's a final ruling in the Texas judicial process entirely as to this issue, COG is going to abide by whatever is determined to be the final determination. COG is not making any kind of indication as to what it may or may not do once this particular court makes its ruling, but I was not intending to make that indication, and I do not believe that I did. But based on what Ms. Vignair said, I felt like I needed to clarify that. We obviously will abide by the law, but our position is as indicated in the briefs.
Yes, no, I didn't have any other understanding. So that was my understanding, and that's what I understood from Ms. Vignair. So I appreciate that clarification. All right, thank you, everybody. We really appreciate your excellent arguments and discussion with us on these finer points of oil and gas law. I do enjoy them, but at any rate, thank you so much, and we will submit this case today based on your arguments and presentation today and the briefs. Thank you so much.
Thank you.
Thank you, Your Honors.
Have
Have
a
a good
nice
day.
day.
Thank you.